Citizenship. Citizenship as a commencement of the Constitution. At the commencement of the Constitution, every person who has its domicile in the territory of India and who was born in the territory of India, either whose parents are born in the territory of India or has ordinary resident in territory of India, not less than 5 years immediately proceeding such commencement, child citizen of India. Determination of citizenship. The questions about the determination of citizenship, even after the limitation purpose of certain other laws, has been done by authority of a light of Constitution provision and the provision of citizenship Act 1955. Lal Bahadur Hussain was the electoral registration officer. Every person include a prisoner, every person include member of armed force subject to Article 33. See as an under-mentioned nation. State of Maharashtra versus Prabhakar Suhil Partha versus Delhi administration. Priti Shah Singh Beti versus Union of India. Domiciles how acquired. The right to change the domicile of birth is available to any person not legally dependent. A person can acquire domicile of a choice by residing in a country of choice with the intention of continuing to reside there indefinitely. Sondur Gopal and Sondur Rajani. One domicile. Under the Indian Constitution, there is only one domicile, that is the domicile of the country, that is no separate domicile for the state. Pradeep Jain, Union of India. Right of citizenship of certain persons who has migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to territory of India from the territory now including Pakistan shall be deemed to be citizens of India and the commencement of the Constitution if he either of his parents or any of the grandparents was born in India and defined in the Government of India Act 1935, originally enacted. In the case where such a person who has migrated before the 19th day of July 1948, he has been ordinary resident in the territory of India since the date of migration. In the case where such a person who has so migrated or on after the 19th day of July 1948, he has been registered as a citizen of India. The officer appointed on behalf of the government on domicile of India. An application made by him is therefore to be set the officer before the commencement of constitutional form and manner prescribed by the government, provided no person shall be so registered unless he has been resident in the territory of India for the last 6 months immediately preceding the day of publication. Note of articles. Catch-up rule. The obligation of the catch-up rule is insertion in the concept of consequential seniors code. The violation of the basic structure of equality code enters into Article 14, 15, 16 of the Constitution. M. Nagaraja, Union of India. Citizenship of foreign state. Article 9 deals with the case of citizenship of foreign state has been acquired by an Indian citizen prior to the Constitution, means that he cannot be claimed citizens of India by virtue of the Article 5, 6 and 8 state of Uttar Pradesh. This is Shah Muhammad. Migrate to territory of India. Migration must be in any the intention to reside permanently in India. This intention may be formed even later. Shano Devi versus Makbal Sin. Migration meaning a government should be voluntarily, not by limited period. Kulanthil Mammoon with the state of Kerala. A domicile on the date of constitution where an accused under section 14 of the Foreigners Act 1946 claimed that he has a domicile in India and was residing in India when the constitution came into force. And the burden is upon him he should be given a chance to prove it. Abdul Sathir Hazi Ibrahim Patel, the state of Gujarat. Right of citizen to certain migration to Pakistan. Notwithstanding anything to Article 5 and 6, a person who has, after the first day of March 1947, migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be citizen of India, provided that nothing in the article shall apply to the person who having so migrated to the territory now including Pakistan has returned to the territory of India under the permit of resettlement or permanent return issued by and under the authority of law. Every such person shall be purpose of Class B and Class 6 deemed to be migrated to the territory of India after the 19th of July 1948. Note Article 7. Citizenship Act. The Article 7 clearly overrides Article 5. It's preemptory in the scope and making no exemption for the case of wife migrating to Pakistan, leaving her leaving husband in India. Even such a wife must be deemed not to be a citizen of India unless the particular facts brings a case within the provision of Article 7. State of Bahia with this Kumar Hayasin. And the scope of Article 7, the Article 7 referred to migration taken place in 1st March 1st 1947 to 1st January 1950. State of Madhya Pradesh with Pir Mohammed. The person continued to be in India. When the person continued to be in India still in July 1950, prima facie virtue of Article 5 read to the Article 7, he was citizen of India on the date of Constitution and continued to be so on the date of offence committed by him on July August 1951. Mohabbat Ali Amin, the state of Bombay. The rights of citizen of certain person of India, origin residing outside India, notwithstanding anything in Article 5, any person whether or who parents or any of his grandparents were born in India defined the Government of India in 1935 and who is ordinary residing in any country outside India so defined shall be deemed to be citizen of India if he has been registered as a citizen of India by the diplomatic or consultant representative of India in the country where he is a time being residing on the application made by him. Therefore, such diplomatic or consultant representation where before or after the commencement of the constitution. It is form and manner prescribed the government or domiciliation of India, government of India. Article 8. The scope of the Article 8 of citizenship. Article 9 deals with the case of citizenship of the foreign state has been acquired by the Indian citizen prior to the constitution and state that he cannot claim citizenship of India by virtue of Article 5 or Article 6 or Article 8. State of Uttar Pradesh, Shahid Mohammed. Person voluntarily acquires citizenship of foreign state not be citizen, or no person shall be citizen of India by virtue of Article 5 to be deemed to be citizen of India by the virtue of Article 6 and Article 8. But he is voluntarily acquired the citizenship of the foreign state. A note of Article 9. The Citizenship Act 1955, Section 9.2. The state government has no jurisdiction to determine the question of citizenship unless function is deliberated by the central government, unless Article 250 of the Constitution undermine the decision supported by the proportion. Government of Andhra Pradesh, Syed Emir, and Akbar's Union India. Migration to Pakistan. Migration contempt Article 9 and 1 before 26 1950 not therefore. State of Andhra Pradesh and Abdul Hasir. Obtaining passport. Mere proof of the fact that a person who obtained a passport from a foreign country is not sufficient to sustain an option for deportation or prosecution unless there has been a decision of central government under the Section 92 of Citizenship Act 1955. The inquiry of the central government under the Section 92 of the Citizenship Act is a quasi-judicial. See under mentioned decision. Government of Andhra Pradesh, Syed Emir and the continuation of this right to citizenship. Every person who is deemed to be a citizen of India under any of the foregoing provision of the part shall, subject to the provision of any law shall have that may be made with the Parliament, continue to be citizen. Article 10. Citizenship and domestic law. In the aspect of the rule, judicial construction regarding must be the international convention norms and construction domestic law. When there is a no inconsistency between them, there is a void of domestic law. Vishka was the state of Rajasthan. Procedure established by the law. Procedure for encoding passport is a procedure established by the law in respect of right to go abroad. Manika Gandhi vs. Union of India. Parliament to regulate the right of citizenship by law. Nothing in the foregoing provisions on the part shall derogate from the power of Parliament to make any power with respect of the acquisition and termination of citizenship in any other matter be in relation to citizenship. Note Article 11. Question of citizenship. The question about determination even the limited purpose of such other law has been done by the authority in light of Constitution provision and provision of citizenship 1955. Lal Bahu Sassin, Electronic Register Officer. Retrospective operation of Citizenship Act 1955. Amending suit involved questioning failing include the provision of Article 9 to the Citizenship Act 1955 outside the judicial and civil court state Uttar Pradesh and Sahadat. A scope of Article 11. The scheme of relevant articles of Part 2 Constitution which deals with the citizenship clearly suggests that the state of Article citizenship has been adversely affected by the state made by the Parliament exercising the legislation power. Ishar Hamud Khan, Union of India. Fundamental rights. This definition it is a part unless a consent of otherwise required. The state includes the government and Parliament of India, the government and the legislation of each of the state, all the local and other authority within the territory of India under the control of government of India. Note of Article 12. Instrumental of state. The bank being an instrumental of state cannot be permitted to make a discrimination on the classification of employees who has voluntarily retired under the VRS schemes and those who are retired under the scheme are declared to be other public sector banks, assistant general managers, state government officers are retired. Shyam Pandey. Agency outside India. Instrumental of agency of state have been operation outside India must comply with the Indian Labour Regulation. Leela Khan, Indian Labour Regulation. The Board of Control of Cricket, BCCI. The Board of Control, BCCI is a registered society, hence it is not a state under the Article 12 of Constitution. And the Cricket Association of Bihar with the Board of Control of Cricket Authority. BCCI is not functionally, financially, administration dominated by government, nor it's under the control of government. Therefore, it's not a state. Zee Telephone Limited is the Union of India. Example of statutory and other bodies held to state. The State Bank of India is also a nationalized bank as a state include the meaning of the Article 12 of Constitution of India. The service of the worksman is also governed by the several standing order and by partial settlement which has been the force of law. The banks therefore cannot take a recourse of hire and fire of purpose of termination of service and the employees. The Bank of India, OP Swarnadkar. The children aid society should be treated as a state within the service article 12 as an undoubtable instrument of the state. Sheba Barshi, Secretary, Children's Aid Society, year 1986. There is a test formulated in the several cases of Supreme Court to find out whether the institution state cannot be deemed to be straight just like a formula. The Tekraj of Union of India, year 1980. Other authorities, that is, what is not the state has been subject matter of each law under the Constitution. Well, from a numerous decision in the subject of adjustment of Andhra Pradesh High Court has been culled under certain proposition. Mr. B. Hussain Ali Khan was the Director of Higher Education Andhra Pradesh. Judgment states that essential test to determine whether the particular institution is other entity authority within the meaning of Article 12, substantial aid and control of government, performance of public functions, and interest in government activities. All these are not essential. It is a particular case. Once in combination of more than one of the may suffice. The leading case of Ajay Hasi and Kadul Muti. This regional engineering college held that the state and P.N. Bhavati observed under the case. The constitution philosophy of the democratic socialistic public requires that government to undertake the multitude of social economic operation and the government having regard to the practical advantage of functioning through the legal device in the corporate empowers and migrate the commercial economic activities by restoring to an instrumental or agency of operation. But the convenience of this carrying out such activities through the corporation cannot be exonerate the government from its basic obligation to respect the fundamental rights and not the override them. The mandate the corporation may be adopted in order to government from the inevitable constraint of red tapism and slow motion. By doing so, the government cannot be allowed to play the truant and the basic human rights. Therefore, it is been easiest way the government can assign the plurality of corporation almost every state of business such as post and telegram, TV, radio, rail, roads, telephone, short every economic activity, thereby cheat the people of India out of the fundamental rights guaranteed to them. In the above judgment of the Supreme Court, Mr. Justice Bhavati indicated the following test for determination whether the entity is instrumental or agency of the state. Now, one thing is clear that the entire share capital of the corporation is held by the government. It would be long way towards indicating that corporation is an instrumental agency on government. The financial assistance of the state is so much as to meet almost entire expenditure of the operation. It would afford some indication of the corporation being impregnated with the government character. It may be also be a relevant factor whether the corporation enjoys monopoly status, which is a state conferred on the state protection. Existing deeps and pervasive state controls can afford the indication that state corporation is a state agency instrumental. It is a function of the corporation of public importance that closely related government agencies. It would be relevant factors in classifying the corporation as an instrumental agency of government. Specifically, if the environment of government is transferred to the corporation, it would be a strong factor supporting of the inference of the corporation being instrumental of agency of government. In Delhi Transport Corporation State. Delhi Transport Corporation, Masood Congress A 1961. The TCL is not other authority within the Article 12 of the Constitution. Sathya Pal Singh and Union of India undermention the decision of seeing the connections. Som Prakash, Union of India, Head of Punjab, Acharam, Sukhre with Bhaktaram, K.S. Ramamurthy Reddy, who is Chief Commissioner of Pondicherry, Sabhati of Union of India, and Mastan's Savib, Chief Commissioner of Pondicherry. Private body is an agency of state, maybe a state or star enterprise of state, City and Industrial Development Corporation of Maharashtra. A duty of employer. The employer within the meaning of Section 12 of Constitution has an sacrosanct duty to act in terms of the sacred objective in the social, economic justice state of Jakarta and Haribhar Yadav. The private unneeded minority of act, not the state. Unneeded private minority act also not the state within the meaning of Article 12 of the Constitution over the government has to no administration control because of the anomaly and under the Article 31 of Constitution. Satmala Sharma State Paul Senior Secondary School. And this definition of state is not conferred on the government department and the legislation, but extend to any of the administration of statutory, non-statutory, judicial, quasi-judicial, and other brought within the fold of state action, being actions violate the fundamental rights in the under-mentioned decision. Ramana was International Airport of Ethiopia, Kulam is the state of Uttar Pradesh, Som Prashad is the Union of India. Even the private body is a state Mahavir Auto Store versus Indian Oil Corporation. State action. The historical extent in which the doctrine of state action involves use is irrelevant of India, but the principle behind the doctrine, state aid, control, and regulation so important in private activities given the color of the state action. It is an interest as to limit the extent of which can be an Indianized and harmonized blend into the constitution and jurisprudency. MC Mehta's Union of India. Sovereign function. Mere the dealing with the subject of the state, the monopoly of the state is a particular event would not be render enterprises sovereign nature. The Balmer Lorry Corporation or the Prati Sharti Sin. Agriculture produce market committee which is Ashok Harini. Assam Small Case Industry Development versus GD Pharmaceuticals. Haryana State Industrial Development Corporation was Hari Home Enterprises. The state of the act fairly. State is required to act fairly, give the due regardings and respect of the rules framed by Bhupendra Nath Hazarika versus State of Assam. The law inconsistent with its derogation of the fundamental rights. All the laws in force and territory of India immediately before the commencement of this constitution, if so far as they inconsistent with the provision of the part, shall be extended inconsistently void. The state shall not make any law with take away the abridge the right conferred with the part or any law made in contravention of the clause shall to be the end of the contravention to be void. In the article, unless the otherwise extent required, law include ordinance, order, bylaw, rule, regulation, notification, customs, usage, having a territory of India in force of law. Law in force includes law passed and made in the legislation, other competent authority in territory of India before the commencement of this constitution and not previously repealed, notwithstanding anything such a law or part therefore may not be in operation either or in the particular areas. Nothing in the article shall apply to the amendment of constitution and article 368.